Does the federal government have police power?
The federal government has authority to enforce its federal law.
Yes, ma'am. But we've talked about the state's police power. Does the federal government have police power?
Well, the executive branch has the power to enforce the law executed by the legislature.
Well, but the federal government can't. The Constitution's pretty clear that you have to have an enumerated power in the Constitution, right, in order to be able to do something?
Well, it's my understanding, Senator, there are enumerated powers, but there are also implied powers in the Constitution.
Yeah, but those are implied to be enumerated. There is no federal police power, is there?
Okay, did you just see that? Because I need a second before we dive into the full video. What you just watched is Senator John Kennedy of Louisiana doing what he does best, and if you're not already a fan, you're about to become one. Senate confirmation hearings can be dry, long, and boring. Half the time nominees just talk in circles until the senator gives up and moves on. But Senator Kennedy does not move on. Senator Kennedy comes prepared. And that snippet you just saw is only the tip of the iceberg. We've got two nominees on the hot seat today, Judge Martinez and a counselor whose last name took about 30 seconds just to establish, and Senator Kennedy is about to take both of them on a ride they were not ready for. We're going to break down everything: the constitutional grilling, the Jones Day drama, the disputed New York Times quote, all of it. And I'll be giving you my honest, unfiltered take on every moment. If you enjoy watching politicians actually do their jobs and hold powerful people accountable, smash that like button, subscribe if you're new here, and let's get into the full video. You do not want to miss what comes next.
Thank you, Mr. Chairman. Congratulations to all of you. Judge Martinez, tell me about state police power.
Senator, my understanding of state police power is the authority of the state officials to enforce state law.
Well, what if the state law is in violation of federal law?
Well, we have the Supremacy Clause under Article 6 of the Constitution that provides that federal law is the supreme law of the land.
Yeah, but that's not an exercise of state power. What's the origin of state's police power?
My understanding, Senator, is also from Article 1 of the Constitution, where the Congress was enumerated certain powers, and under one of the provisions of Article 1, anything that was not specifically enumerated.
You don't think it's Article 10?
Well, Article 10 has to also is also applicable.
Actually, the 10th Amendment. What does the 10th Amendment say?
The 10th Amendment provides that any specific power that was not given to a Congress or denied to the states applies to the states and the people.
And that's the origin of a state's police power, right?
Yes, Senator. Okay,
it's not Article 1.
I read it as both, Senator, but if it's Amendment 10, then it's Amendment 10, Senator.
Does the federal government have police power?
The federal government has authority to enforce its federal law.
Yes, ma'am. But we've talked about the state's police power. Does the federal government have police power?
Well, the executive branch has the power to enforce the law executed by the legislature.
Well, but the federal government can't. The Constitution's pretty clear that you have to have an enumerated power in the Constitution, right, in order to be able to do something?
Well, it's my understanding, Senator, there are enumerated powers, but there are also implied powers in the Constitution.
Yeah, but those are implied to be enumerated. There is no federal police power, is there?
Well, Senator, my understanding is that the executive branch has the power to execute the laws of the United States.
I know, but that has nothing to do with police power. Let me move on. Counselor, tell me how to say your last name.
Suknanan, Senator.
Say it again, please, ma'am.
Suknanan.
Suknan?
Suknanan.
Suknanan, okay. Counselor, you used to practice law at Jones Day, is that right?
That's correct, Senator.
Okay. And there was an article in the New York Times. I don't know whether you leaked it to them or somebody from your law firm leaked it to them. Your firm, Jones Day, you were a partner then, and you were representing a party, your firm was, and you were, in a post-election challenge to Pennsylvania, the Pennsylvania Supreme Court. The Pennsylvania Supreme Court, of course, extended the filing deadline for absentee ballots in the president's election, and that was challenged as being unconstitutional under both the state and the federal constitution. Am I right?
Yes, Senator.
And Jones Day was handling that case, right?
That's correct.
And you were a partner at Jones Day, is that right?
That's correct, Senator.
Okay. And who was your client in that case?
The firm's client was the Pennsylvania GOP, Senator.
Well, it's your client too, right?
Correct, Senator. I was not the lawyer in that case, but yes, Senator.
But you were going to share in the profits made from the bills paid by the Pennsylvania GOP, right?
Senator, it was a firm client. I was a partner at the firm.
And you were going to share in the money, right?
Correct, Senator.
Okay. And in a call where you and some of your partners were talking about the case, this is what you said about your client who's paying you. You said, this is according to an August 25, 2022 article. You said, quote, "This lawsuit was brought for no other reason than to deprive poor people of the right to vote," close quote. You said that, didn't you?
Senator, those were not my words. I do not know who provided that quote to the reporter.
You gave it to the reporter, didn't you?
Senator, I never spoke to the reporter or anyone in the media about the meeting in question, and I'll tell you why. As a partner at Jones Day, all partners are bound by a confidentiality obligation to the firm. And that meeting was an internal, confidential partners meeting.
Yeah,
I never spoke to the media about it, and those were not my words, Senator.
This is a violation of about 927 provisions of the Code of Ethics, isn't it?
Senator, that's why I never spoke to that reporter, and those were not my words. I do not know who provided that quote to the reporter.
What did you mean? Who was trying to deprive poor people of the right to vote? Who were you referring to when you said that?
Senator, as I said, those were not my words.
Oh, you never said that. You did not.
Senator, those were not my words.
If we deposed your partners on that call, they would say, no, she never said it.
Senator, I am telling you here today under oath that those were not my words. I never spoke to them.
If we deposed your partners and put them under oath, they would say, no, she never said that?
Senator, I can't tell you what someone else would say under oath. I can tell you under oath that those were not my words. I never spoke to the media about that call.
And you think in light of this, you're qualified to be a federal judge?
Senator, I never spoke to the media.
You would say that about a client?
Senator, as I said, those were not my words, and I never spoke to the media about the meeting in question. I take my obligations, ethical and otherwise, incredibly seriously.
You said that, didn't you?
Senator, I did not say those words.
So the New York Times got it wrong?
All right, we've watched the whole thing and I have thoughts. Let's start with the constitutional exchange between Senator Kennedy and Judge Martinez, because that part alone should be required viewing for every law student in America. Senator Kennedy opens by asking about state police power, a foundational constitutional concept, and Judge Martinez stumbles almost immediately. The nominee attributes the origin of state police power to Article 1 of the Constitution. Now, I'm not a constitutional scholar, but even I know that's not right. It's the 10th Amendment. Full stop. And Senator Kennedy, calm as ever, guides the nominee there, not rudely, not with theatrics, just methodically, like a professor who already knows you didn't do the reading. Then comes the federal police power question, and that exchange was fascinating. Senator Kennedy makes the point that the federal government must have an enumerated power to act. There is no general federal police power. The nominee keeps pivoting to implied powers and executive enforcement, and Senator Kennedy keeps pulling the conversation back to the core principle. He's not trying to trick anyone. His testing whether this person who wants to be a federal judge actually understands the document they'll be interpreting for the rest of their career. That's not political, that's just responsible. Now the second half of the hearing is where things get intense. The counselor is a former partner at Jones Day, a major law firm. Senator Kennedy establishes the connection clearly. The firm represented the Pennsylvania GOP in a post-election challenge. The counselor was a partner, and therefore had a direct financial interest in the outcome. That's not an accusation, that's a fact the public deserves to know when evaluating someone nominated to a lifetime federal appointment. Then comes the bombshell. Senator Kennedy cites a New York Times article quoting the counselor during an internal partners meeting as saying the Pennsylvania lawsuit was brought solely to stop poor people from voting. The counselor denies it, firmly and under oath. I'll give credit where it's due. The denial was consistent and confident. But here's where I stand. Senator Kennedy's job is to surface these questions before someone gets a lifetime appointment to the federal bench. Whether the quote is accurate or not, the American people deserve to know it exists, that it was published in a major national newspaper, and that it directly contradicts the impartiality you'd expect from a federal judge. Senator Kennedy didn't convict anyone in that room. He asked the questions. That's exactly what a senator is supposed to do. What I appreciate most about Senator Kennedy's style is that he lets the facts do the work. He comes in with specific articles, specific constitutional provisions, specific dates. The nominees end up looking unprepared not because Senator Kennedy is playing gotcha, but because he clearly studied harder than they did. And that final line, asking whether the counselor is truly qualified to be a federal judge, that wasn't just rhetorical. It was a genuine challenge. If you want to sit on the federal bench, you need to answer basic constitutional questions and withstand serious scrutiny about your professional conduct. Both nominees struggled to do that. People can disagree with Senator John Kennedy on policy or politics, but in that hearing room, he had done his homework, he treated the confirmation process with the seriousness it deserves, and he asked the hard questions that too many senators are content to skip. That's the job. And Senator Kennedy did the job. Let me know in the comments whether you think the nominees handled the questioning well or whether Senator Kennedy exposed some real gaps. Like the video, share it with someone who needs to see it, and I'll catch you in the next one.